Ladies and gentlemen, welcome to today's episode on No, but seriously, let me explain. Hosted by the beautiful, intelligent Earth Angel Lala Davi. This podcast was designed to provide detailed business advice, next level resources, personal credit tips, and relatable relationship knowledge. Be sure to bookmark this page and subscribe because we wouldn't want you to miss any valuable content. And if you're struggling with poor credit, don't even worry about it. Just text Help My Credit to 507-400-3426. That's 507-400-3426. We have live agents standing by to cater to all your service requests. And now that that's out the way, let's make room for what the host has to say. Lala Davi, do your thing, girl.
Welcome to No, but seriously, let me explain. This phenomenal podcast series keeps you fully engaged with all the tips and tricks that you need to be successful, while also providing plenty flavor. I am your host, Lala Davi, and today we will discuss legal tactics. Do you fully understand your legal rights to help you challenge and address something wrong? No, but seriously, let me explain. What strategies can you use to really prepare for court or really maximize your chances for a favorable outcome? Most of the time, individuals don't fully comprehend the legal jargons wrapped around the complex nature involving law. Don't worry. We're going to make it easy because it is easy. It's common sense, actually. We're going to analyze the rules on court to really reveal the pattern and just a simple process from the initial complaint to the final judgment, which is signed by the judge. Sit back and relax, grab a soda or coffee, put your feet up, and just really begin to listen, as this will definitely help you along the way. Whenever you begin to learn the rules of the justice system, you want to really just look at the anatomy of every lawsuit so you can really see the big picture. There always be different details that you can really just tap into. So just to keep you on a straight path so you don't get confused, you want to study the contents of the proceedings very carefully, okay? You want to make sure that you read through the outline because it's important to really know your part from beginning to end. And then you'll really notice a pattern within the documents itself, keeping in mind that you've already won the battle because we're already winning, right? We're focused on winning, not losing. Winning lawsuits really begins with knowing the rules. Imagine yourself trying to win a poker game or a game of basketball and you don't know the rules. Like, how can you accomplish this, Way? Like, please tell me. Can you do this? Of course not. The same rules really apply in court. The consequences for not comprehending what's going on in court is much more severe, with higher stakes involved and potential catastrophic outcomes. On the other hand, if you know the rules and you have a strong case, then you'll probably win. That's why having rules, that you can read and comprehend and follow through is always going to be good in order for you to have higher chances at a win. Rules are written for a purpose, of course. So the justice system has a certain set of rules depending on which court you're going through. The court system itself established these rules, and without them, the courts could not function. So there must be some rules. Okay. The rules control the judges on the other side, and you, giving you the opportunity to really present your case and demand fair hearings and trial if needed. These rules truly are easy to follow and understand, of course, if you remember the step-by-step procedures. Standing on a solid footing when you're fighting these legal battles is going to be important. The official state rules are not expensive. You can always pull them off the website. Sometimes they charge a fee for that. However, you can pull them based off of your jurisdiction in your state. If you're involved in a lawsuit, of course, or you're anticipating being involved in one in the future, then it's best to invest and make sure that you have one. At least download the Federal Rules of Civil Procedure or go to your state and download them there. You want to make sure you have them. You want to know the rules that control that particular court in your state just to make sure that you're obeying them. And of course, anytime there's a civil lawsuit, there's going to be full comprehension that's needed in order to fully see this lawsuit out. And we can start by calling it a CAT, okay? Your C is the complaint. The plaintiff files a complaint to start the case. So remember that. And then the A is the answer. The defendant has to respond to that complaint, right? Okay. And then the T is the trial. The judge or the jury really examines the evidence and makes a decision. For every civil lawsuit, follow these basic steps, of course. After each plaintiff files a complaint, the defendant can try to dismiss it with motions. If these motions fail, the defendant must answer the complaint. Both parties can then gather evidence through discovery. If they decide to settle the case, they can settle out of court. But if they cannot settle the case, then that's when it's going to trial, where the judge or the jury decides the outcome. And the burden of proof is always on the other party that's making the claim. So the burden of proof will be you if you're filing a claim, Mr. Plaintiff. So for an example, if someone sues you, they must prove their case. You don't have to prove that you didn't do it. They must prove their case, and you can fight against that. In court, when you're presenting your case effectively, that really means just making a clear record of all the facts, all the laws that really support your position. You want to use written motions, of course, to ask the court to act, and always ensure a court reporter is present to record everything. This just really ensures that the justice and the judge really follows the law, pretty much. But remember, each fact and every law, you need to prove it like it's a string of pearls, pretty much. You want to wing that thing one by one, proving each point one at a time, and you'll build a strong case. In your civil lawsuits, it's really about comprehending both the procedural and the substantial laws. And that's going to be the crucial point in basically fighting your lawsuit. Procedural laws really guide you how the case moves through the court, while substantial laws, they deal with the actual issues like breaches of contracts or injuries or so forth. Knowing these laws really help you navigate and win your case. So all you really have to do is just focus on building the truth and using the court's rules to your advantage, and always keep a detailed record every step of the way. Like, this approach will definitely guide you to a successful outcome. Not to mention you having the ability to use the court as your bank. Like, when you receive a court document, the court has just begun. It's not just about the physical courtroom, it's about the paperwork. The paperwork is the venue. Yes, it sounds wow, but it's true. Controlling the court really means controlling the paperwork. And when I say controlling the court paperwork, it really involves just having this mental shift, understanding that the paperwork is the court, and then responding strategically, sending back questions, and following the administrative process. You could also use the Postage Stamp Act as well, placing the $1 U.S. postage stamp over your response letter. By doing this, it shows awareness and control over that venue. When you cancel the stamp with your thumbprint and autograph, you become the postmaster of that document, controlling the court process. Mastering the court's motions is basically, having a motion to request from the court. And it's not just for attorneys. You can make motions too. A well-crafted motion can influence the player of the courtroom, from the judges to the clerks. And the way to do that, you can do it by admissible evidence, demanding evidence that the plaintiff claims. Also by witness testimony, requiring witnesses to prove their claims. You can also do it by beneficiary proof. Ensure that you're recognized as the beneficiary of any financial dealings. And then there's something called the trustee clarification. And this just really confirms that the court officials and trustees are handling the settlements. When you're speaking of contract law in court cases, all court paperwork is essential for a contract, and you need to treat it accordingly, of course. You need to understand the terms, clarify the language and conditions of the contract, and then there needs to be some type of conditional acceptance. Respond with a conditional acceptance of the offer. When responding, you want to assume that there are defects in a document and ask for clarifications on the language if you need to have clarification. Perform a forensic analysis to uncover flaws if you need. And also have some type of timeline. Include a timeline of your motions. Like specify that all requirements must be met within a certain period, like 10 days, 30 days, whatever you want to give. If not, that motion stands as a motion to be dismissed. Just make sure that whenever you're writing your motion, you got some power in that motion. And there's a few things that you want to really consider when you're really filling out the demands and requirements, especially for all those key players, the judge, the attorneys, clerks, prosecutors, magistrates, and anybody else involved. You want to make sure those key players are fully informed and are fully aware of what's going on when you write this proper motion. So, just a few things when you're writing out your motion. You want to require that the plaintiff provides some type of admissible evidence that the name, the legal name, the all caps name on the complaint is exactly the same name as whoever you, the living man or woman, is, of course. Like, require for the plaintiff to provide a witness who will sit on the witness stand and provide some type of admissible evidence that you are dead, just like the all caps name. You want to make sure that you also require that the plaintiff provides the name and contact information of that witness who will sit on the witness stand and testify that somebody other than you are the beneficiary of that money of the courts. And that will make the case from there. Why? Well, the courts are nothing more than just a bank. They're a banking institution and they're making millions of dollars by monetizing the QSIP. Yes, I said the QSIP. And by trading that on an open worldwide stock number associated to that case. And that's why when you connect with these brokers and you go to like the Fidelity sites and put those case numbers in the site, it actually pops up some type of value on the case. But of course, that's a whole nother ball game and a whole nother story. And I can break that down in another video, of course. So going back to the courts being your bank, whenever you have these monetized systems in place, the courts can do this by making themselves the beneficiary, of course. And by law, the only beneficiary of any money made by that CUSIP is you. So there is no witness that can be brought forth to prove that you're not the beneficiary. By making this requirement, you're automatically shutting down the power of the court to make millions on this case. You want to require a witness who will testify that the judge and the prosecutors are not trustees, whose role is to pay and settle any money or jail time owed by you if you lose the case. If you take a look and recall House Joint Resolution HJR 192, that pretty much took all the money out of circulation, out of the United States, which made all the citizens of the United States bankrupt, which means no citizens have any power to pay for anything, right? Okay, well, as a result, by the judge and by the law, the judges, prosecutors, and those working in the court system, they have become the trustees. And as the trustees, it is their job to pay for any debts owed by you. That means that there is no witness that can be brought forth who can testify that you are supposed to pay instead of the judge or prosecutor. So if such a witness were to be brought forth, their entire cheat system will be revealed on the record, and no judge would ever allow that. You need to require that all parties, including all judges, prosecutors, plaintiffs, magistrates, attorneys, and court-related staff, submit their 1099 OID to you for the taxes due for the money that they make off of that court case. Yes, I said it. You want to make sure that all court-related staff submit their 1099 OIDs just so you can pay the taxes that's due for money, that's going to be made on that court case, okay? Yeah, it's a thing. Courts make money, right? Let all the parties know that if they do not submit their 1099 OID to you, then you will have no choice but to report their activity to the Treasury Inspector General, to the IRS CID on a Form 4490 and Form 8281. And also let them know if they do not submit their 1099 OID to you, then you are required to report the entire activity to the post office. And you also plan to alert the Universal Postal Union because of the possible money laundering. None of this is a bluff on your part, and they know it, especially the judges and the prosecutors, the magistrates, and the courts of clerk. As you can clearly see, by making these requirements a part of your motion, you're really controlling all the players in the court case. You're definitely the one controlling the game, coach. Like, you're controlling the players, and now you're controlling the clock, as if the paperwork wasn't speaking for itself. Like, all the paperwork falls under contract law. Why is that, coach? Why is that? Well, that's because the entire court process is banking. And all banking really uses is words, and all the words falls under contract law. Since we know about the contract law and the entire process about contracts, then isn't it important to just know what all lawful contracts really contain in a time frame? Like a clock, which typically begins when counting the moment you agree to the contract. Since your court case is nothing more than a banking contract, it's vital to make sure that you make the time frame a vital part of your motion. So anytime you're doing these motions, after setting the requirements which control the players, you want to include a time frame and by which, these requirements have to be met, right? In addition, you want to let these players know that the consequences of not adhering to your requirements. So, yeah, all your motions will have similar language that sounds like this, pretty much. And this motion goes into effect if all required matters are not fully disclosed with supporting evidence within 10 days of the receipt by the court and responded to under oath by the responding parties. Why did I just read it? That's like that. But, just basically adding this to any motions, like you're controlling the clock. But since your contract and court case, I said contract, but since your court case is nothing more than a banking contract, it's really vital that you make sure that you make the time frame a vital part of your motion. So anytime you use these motions to scare judges, the clerk, or the attorneys or prosecutors, or the other court workers, can't forget them, not only do it put you in control of the paperwork, the venues, and the players, and the clock, the motion also acts as a motion for discovery and conditional acceptance, and as a motion to dismiss the case. Like, as a motion for discovery, like, it's required that all parties really tell their admissible evidence up front, including the names of all their witnesses. But none of their evidence is really admissible. And they really don't have any living actual witness who can really take stand and accuse you or whoever the case is for. Why? Because all their witnesses are fictions. And if you're not familiar with the term fictions or legal entities that look identical to your living name, the name that you go by, then you just might want to go back over to my podcast, episode 2. No, it's season 2, episode 7, and just listen to The Secured Way just to get more insight on that overall and to see what a legal fiction is, especially when I'm referencing it here. Like, do you know what a fiction is? Like, they can't sit on the witness stand. They can't talk. They can't walk. Hell, they can't even breathe at this point. But since the law gives, us the right to face our accuser, and since they cannot present a fact witness, they cannot win a case against us. And then the conditional acceptance is just willingly accepting all of their accusations and charges, but only on the condition that they can provide all your requirements, of course, right? But they can never provide all of your requirements, because if they did, then their entire dishonest scheme would just be revealed before the courts. And that would be the worst case scenario, right? And of course, they would never willingly or openly reveal this scheme. Of course not. So, since they cannot provide the required conditions, they cannot win their case, right? So, in that point, that allows you to provide a motion to dismiss the case. Because, why? Let me tell you why. If you haven't been listening up to this point, like you should already know, right? But if you do not provide all of my requirements in 10 days, then this motion will stand as a motion to dismiss, right? Because you asked for it a while back in your requirements as a part of your discovery, right? Yes, you asked for all of that, and they cannot supply that, right? So that is leading up to your motion to dismiss this case, since no judge in his right or her right mind would ever allow any of your requirements to ever be met by any court-related employees for fear of revealing this scheme. The judge is left with no other choice but to dismiss this case with prejudice. And when I say with prejudice, that simply means that this case can never be brought up again. Okay? Anytime it's dismissed without prejudice, that means you can always bring it up. So keep that in mind. Whenever you're submitting your documents, you want to stay away from terms like straw man and sovereign citizen whenever you're submitting your filings because the judges, they will mark your filings as frivolous, utterly frivolous at that. Like, have you ever heard or read a court case that stated citizens are not sovereign? Many people lack the true understanding of sovereignty, like who is really considered sovereign and what it really means. Rarely do individuals take the time to read the law and study in the law library. Instead, they make claims about sovereignty without really consulting with anyone or consulting the court cases or fully understanding the historical context that really explains it. Like, how can you assert that citizens are not sovereign without examining case law or diving into the history behind it that really clarifies this concept? Like, most people are merely just repeating what they've heard on the internet or other people say without doing their own research. Like, the people are sovereign. Some people claim, state citizenship. Since you're a citizen of the state, but does that make you sovereign? I see people claiming to be sovereign citizen, which is an oxymoron because you can't be both of them. You definitely have to use your intelligence. Like, those in government, they will know. And many people are uninformed about it. And they explicitly just lack the knowledge by using this deceptive language to mislead you, banking on the assumption that you won't take the time to read or educate it on, your own time. Corporations can never be sovereign. However, people have been misidentified as corporations. Thus, those who identify as persons are really considered corporate persons claiming citizenship of a corporation, like an official person. If you go to the Cornell Law or Law Library, whatever, and look it up, an official person, what it is, it states that an official person is a non-human legal entity that is not a single natural person, but is an organization recognized by law as a fictitious person. In the United States, an official person refers to any entities established under the law in the United States, of course. So look that up. Most people tend to confuse the term citizen of a corporation with citizenship of an organic government. And these two are two different entities. Understanding and comprehending the term sovereignty and its implications is crucial. It's not only important to recognize your relationship to it and what it really means. Like, if you were a sovereign and you're facing traffic tickets or arrest of some sort for a vehicle-related incident, automobile-related, anything. If you identify as sovereign and you have received tickets for offenses with, no insurance, no tag, no registration, no driver's license, or at worst, you've been arrested and your automobile has been impounded. Like, there is certain things that you can do, to proceed with this. Like, first thing you would need to do is file a motion. You need to dispute the contract on any grounds that you believe were violated, such as, fiduciary duty or breach of contract or the account stated. Like, this process takes time and it involves a procedure, of course. And then not to mention there's affidavits. You need to fully understand that affidavits are out of the court's statements with no bearing unless you testify to the validity in court. Like, you cannot file an affidavit without following up on it or appearing in court to support it. Like, always make an affidavit on the record to be heard. And then you have to really distinguish motions and affidavits. Both are forms of filing, but there's a lot of misconceptions that exist among sovereigns regarding the differences. So if any filing you do places you under the court's jurisdiction, And then a lot of the times they like to say that sovereigns tend to confuse jurisdiction with authority, while courts sometimes gain jurisdictions. They never really give authority over to you. Like, you have to have authority to dispute any validity of any contract or any case at any time. And then really fully understand the court's role. You need to recognize that loan servicers, banks, and courts, they often bond penalties and charge premiums for the release, making individuals liable. Courts act as banks, not as institutions of justice, focusing on commercial interests rather than criminal ones, And then you need to really just gather your evidence. You need to prove court fraud through documentations, that you submit, not assertions. Using all of their CAGE forms or CAGE codes and GSA forms and other relevant documents to assert that courts operate as banks, then you're going to present your case. Avoid telling courts that they lack jurisdiction without evidence. I see a lot of people saying, no, you lack jurisdiction or you don't have jurisdiction over me. And then bam, slammer. Instead, you need to prove it and with proper documentation. Keep your approach simple, state your case, move, and then defend. Like, there's no need for you to fight yourself. Like, a lot of sovereigns tend to harm their cases by using, the terms that I mentioned, straw man or, sovereign citizen, or, feeling as though they possess this professional knowledge that they don't have. And then they proceed to just win the case in the way that they feel that they can win. Instead, you just need to keep your approach straightforward and avoid any unnecessary complications. Like, you do have the possibility to win without an attorney, understanding that hiring an attorney just gives them power over you. Attorney signs this custodial affidavit in your name, which benefits the judge, the prosecutors, and themselves. Okay. Most attorneys won't fight hard to win cases as they fear financial repercussions from losing from the prosecutors. Like, I can't state that enough. Like, you're better at fighting your own case. Just, learn case law or, study the case laws that's relevant to your case, learn contract law, if anything. You want to make sure that you remain informed, like realize that the legal system benefits from your financial contributions, and lawyers are just a part of that system. The more you pay, the better your chances are beating the charges, of course, but it's crucial to remain aware of the underlying dynamics. In all seriousness, do you know what a law enforcement officer may need to conduct an investigatory stop? No, but seriously, let me explain what it is. This is often known as a stop that's, been treated as a temporary form of detainment. And they're just basically investigating during this time. So just to give a real life scenario, say for instance, you're pulled over by the police. And you wasn't speeding, you didn't run a red light, stop sign, hit anyone, or any of that. So, in this case, what do you do? What do you say? Is this illegal for them to just pull you over at this point in time? No, but seriously, during this time, the officer must have RAS. And basically what that is reasonable, articulable suspicion. And to basically provide emphasis on that, the RAS must be based on specific and articulable facts and not just a hunch. Okay? So anytime, whenever you're pulled over by police, law enforcement, they must have that and be able to state it to you under the color of law. And what is that? Please do tell me. Well, that basically means that they must provide examples of actions that fall under this term, such as a false arrest or unlawful searches. Of course, like they do not have the ability to abuse authority at all. So in this case, you would definitely want to exercise your rights and know just how not to enter into invisible contracts. And what is an invisible contract, might I add? Well, let me just explain that to you further. An invisible contract definitely refers to an agreement or obligation that is not explicitly stated or signed, or it might be implied by actions or circumstances, of course. So, in the context of the courtroom and police investigations, these can definitely arise through various means, such as statutory obligations, presumed consent, and implied consent based on behavior. And because I'm so nice and so considerate, I just want to mention a couple ways that you can enter into an implied or an invisible contract without knowing. Like in a courtroom, if you appear in court as, you normally do, or anyone that is, summoned to go to court, a person may, enter into this contract unknowingly and acknowledge the court's authority over them. And this can happen even if you do not explicitly state it. Failing to challenge jurisdiction early can be seen as an implicated, or implicit agreement to be subject to the court's authority. And then you have these procedural compliance, agreements, engaging in legal processes such as filing the motions or responding to the summons and, participating in their hearings. That implies, your consent to the court's rules and procedures, of course. Like you're going with the motion at this point. So, of course, you're on contract now at this point. Like this is considered a implicit contract where individuals agreed and abide by the court processes that they're participating in. And then you have the acceptance of legal representation that I mentioned, of course, before with these lovely attorneys. Like when a defendant uses a court-appointed attorney, they are entering into an implied contract, accepting the terms and conditions of that representation. And that just basically includes the strategies and decisions made, on their behalf, of course. And not to mention, we stated police investigations can have implied contracts too, these invisible contracts that you don't know about. Whenever they, search your car, you consent to a search. Like you voluntarily allow this. Like if a person voluntarily allows a police to search their property without a warrant, they are entering into this invisible contract by consent, by allowing it. Like this sometimes occur without, your verbal agreement, of course, and such as operating or just opening up the door when they say open up the door and widely stepping out to let them in. Like you just entered into the contract. And also, not to mention the Miranda rights. When a suspect is read their Miranda rights and they choose to speak to the police without the attorney present, they're implicitly agreeing to waive their right to silence and legal counsel during this questioning. Like, you can definitely utilize your rights, please, and thank you. So, going back to it, you can either comply or not comply. Like I suggest, following and, utilizing your rights to your fullest ability. Compliance with orders, with following the police commands, such as pulling over when, you signaled to pull over, or by complying with instructions during the stop, can be seen as entering into this agreement following lawful orders. However, we all know if you do not stop when they signal for you to stop, you're going to get ran off the road. So people willingly enter into this contract, this invisible contract, knowingly at that point, because They don't want to have any, additional repercussions caused by, high-speed chase or anything of the sort. So typically, out of fear, most individuals will go ahead and stop once they see those lights. And it's a scare tactic once they put those lights on you. We have come to a very short commercial break paid for by our lovely sponsors. So don't go anywhere. We will be right back after this message.
Yeah, what up, ATL? Look, you ballin', you bad and bougie with bad credit. That's most of y'all. But look, man, that's why y'all need to call my people at Exchange Credit Repair. That's right, Exchange Credit Repair will help you squad them inquiries, get rid of them collections and bankruptcy. They'll even take child support off. I didn't even know they put child support on credit. Woo-wee! And boost your credit score. Let's get that credit score where you want so you can go get what you want. And if you mention Street 945, you get a 35% discount. Hein? So call my people right now at 678-420-5553, 678-420-5553, or visit my people at exchangecreditrepair.info. Exchange Credit Repair is a credit counseling business with experienced credit repair experts standing by to assist you right now. When I made this deal with them, I said, look here, you ain't got to pay me for the commercial. Just put my credit score where I want so I can go get what I want. When I went to them, they treated me like family. My privacy was all the way respected. They quick to fight for a client's right with the Bureau of Credit, creditors, and debt collectors. Conveniently located at 1 West Court Square in Decatur. Tell them Shout sent you.
From now on, I definitely want you to remember a couple things. You want to sign all agreements and contracts using your first and middle name, comma, trustee, if you're using a trust. And then you're going to comma that without prejudice. When creating legal documents, replace affidavits with affirmations. The following could just be in terms of how you really present your case and your situation, like an acceptance, Your Honor. You want to agree to and fulfill any requests. For your conditional acceptance, Honor, you want to agree under certain conditions, of course. Then for refusal for a cause without dishonor, reject erroneous claims per UCC 3-501. Your argument is dishonor. You want to dispute the claim if necessary. And your refusal is dishonor as well. Default by not responding. So just remember that. Use refusal for a cause to prevent claims from being collectible bills. Mark the presentment conspicuously and return it back to sender, possibly filling it out through the USDC clerk of court or PACER to establish it on record. Remember that criminal charges usually require an injured party of some sort. Without proof of harm, it is difficult to establish the basis for a crime. However, the state can sometimes be considered the injured party, especially in cases of theft or assault. Empower yourself with the knowledge and understanding of the law is the first step to ensuring that your rights are protected and just shaping your destiny. Remember, you're not in this fight alone. You do have the resources and knowledge at your fingertips. Of course, there's always resources below inside of the podcast description for you to utilize and view at your own discretion. Please be advised, all of this information is not to be misconstrued as legal advice for your case, more as a legal basis for you to follow as a guide. Thank you for joining us on this podcast journey. We hope that you have found this information valuable. To our fantastic listeners, your support means the world to us. Share the insights with a friend. And if you haven't already, hit that subscribe button and stay tuned for more exciting content. A massive thank you for being a part of No, But Seriously, Let Me Explain. I am your host, Lala Davy, the one with all the sauce, of course. Until next week, stay bold, beautiful, and brilliant. Love ya.